today's episode, we're going to talk about a very popular topic, and that is when and when not to file for an ex parte. What's going on, everyone? It's Mark Real Jr., the Father's Rights Attorney, and we're here with another episode of the Father's Rights Playbook. And on today's episode, we're going to talk about a very popular topic, and that is when and when not to file for an ex parte order. And to discuss that with me, I have San Diego Senior Trial Attorney James Rudolph. James, how are we doing?
Doing well. How are you? Thanks for having me.
I'm good. So you are the perfect person to have this conversation with. I feel like 3-4 times a week I see in the firm chat that you've won an ex parte, we've gotten favorable orders. So we'll hop right in. Every single time we hop on the phone with a client for the first time, they think it's an emergency. Unfortunately, we have rules and laws in place, and not everything constitutes an emergency. So we'll start out with, what is requesting an ex parte hearing? And then number 2 is, when can the court grant that ex parte hearing?
So yes, I heard a judge once say that if it takes an inch of paper to explain it, it's not an emergency.
No.
So it should be apparent on the face of the paper, the pleadings, that it is indeed an emergency. It just means that it can't wait for the regular calendar. Sometimes it takes 3 months to get a hearing on the regular request for order hearing.
Yeah.
So the ex parte emergency option is there to address what they call irreparable harm. So that means there is an allegation of abuse or sexual abuse against the child, or the threat of removal from the state of California.
That's the one right there. That's the automatic trigger that actually has its own section of the family code, is if there's the threat of fleeing the state.
Yes. There's another one. It's not in the actual code, but case law adds negligent supervision to one of these emergency situations where the court could come in and on a very quick, and by quick I mean 24 hours, hear your case. It's a very short hearing, 10 to 15 minutes. Like I said, it should be apparent on the pleadings that there is an emergency. The court is concerned about the child's safety. There are other issues that are not related to custody, but most of the issues are custodial issues. And
I think that's where we get most of the asks as well.
Yes, I've had many of these. One just today was based on the threat of removal. The child had been removed, and mom had gone missing for 4 or 5 months, and we got the court to issue an emergency protective order. And so that was very satisfactory to the client. And so it's really meant for those true emergencies that cannot wait 3 or 4 months, because their irreparable harm means if they do not take action today, their rights will be undermined in the absence of court intervention.
Yeah, and I think it's another thing for our listeners and viewers is it can be dangerous to your long-term case outcome to file ex partes when they're not necessary. We would love for every single client whose child is being withheld to immediately file an ex parte request. We would love that. But can you talk through some of the reasons why you don't want to file that ex parte, especially when it's not that critical emergency?
Yeah, so you're really stuck with your judge. When you get assigned to a certain judge, that judge, if he or she decides to deny the request, is the judge who will be hearing your case 2 or 3 months down the road. So if you seem too impatient, and everybody has to wait in line, we're all frustrated with the timeline, but that's the way it goes. And if you're seen as trying to jump the line by creating allegations or making a mountain out of a molehill, then the judge can be not favorably inclined to your case as it moves forward, because you're now seen as having made trumped up charges and things like that. So
family court's a credibility contest.
Yes,
and you can lose a great deal of that credibility by crying wolf.
Exactly. So I've heard somebody call family court liar's court, and the judges know that, and they have to sift through these false allegations every single day. And so it's like crying wolf. If you do it, you might not be believed the next time. And yes, it is about credibility, and you want to maintain that going forward, is be seen as the parent who is not trying to undermine the other parent's custodial rights. They really want to see parents being mature and cooperating and putting aside their issues that they have that led to the breakup of the relationship.
Yeah. And I think another critical point to talk about in this is that the granting of an ex parte request is very heavily judge dependent and is handled differently in different counties.
Yes.
Most of my work was in the Inland Empire, in Riverside and San Bernardino. Riverside, you file an ex parte. You give them notice by 10, you file by 2, you show up at 8:30 the next morning, and the judge hears oral arguments. In San Bernardino County, you notice by 10, you file by 2, the judge on the morning recess in chambers decides on whether they're going to hear the ex parte. You don't know, but you don't know the day before. Walk through what it's like in San Diego with the ex partes.
It's very similar. You have to give notice before 10 a.m. That can be a phone call. Typically, we do a phone call, an email, just to make sure. And that is based on the previous communication between the parties. Whatever it is they were doing before, whether it's Talking Parents or one of these other apps, you give notice. You tell them that the ex parte has been filed, that there will be a hearing the next day at 8:30. Typically, it's 8:30 the next morning, sometimes in the afternoon. And this is necessarily a what they've called a truncated process. It's sped up, and it does implicate due process rights. That's why they are very rarely granted, because you're supposed to have notice, you're supposed to have time to go get an attorney to gather your evidence in opposition to the claim.
Yeah.
But because of the threat, the irreparable harm, the court will abbreviate the process, notwithstanding your due process rights.
And that's another thing too, is, and we're on the receiving end of just we probably file more ex partes than we receive by the nature, the dynamics of family court. But it sucks when you go in on the other side of it. And best case scenario is late in the day, you were able to get a hold of their filing and you draft up a response and you walk it in. A lot of times you're just going to have to make oral arguments on why it should or shouldn't be granted.
Yes, that's true. And, it just depends on the nature of the allegation. I tend to see it as another option, and if the case is good, if the allegations are good, I have no hesitation filing for an ex parte. It's another tool that can be used to protect your rights. They're typically temporary orders, so you have another hearing scheduled
30 to 90 days out.
Yeah, depends on what it is the orders were granted for. And so it can be seen as setting the stage. You can now have custody. You can then argue that you've had a pattern of stability with the child, and that the temporary orders should be continued.
Yeah, definitely. Well, James, thank you so much for all the great information on ex parte hearings. To our viewers and listeners, thank you again, and we'll see all you guys again next week with another episode of the Father's Rights Playbook.